واغفر لنا ذنوبنا وكفر لنا سيئاتنا وتوفنا مع الأبرار. ربنا وأتينا ما أعطنا على رسلك ولا تخزنا يوم الهيابة إنك لا تخلف الميعاد. اللهم بذل قد وافيت بابك أعلما أن تزلل عند بابك ينفخ وجهلت مهتمدي عليك توكلا وستكافي سائلا أتدره وبحق من أحببته وبأسته وأجبت دعوة يتصفه. اجعل لنا من كل ديه مهرجا والتف بنا يا من إليه المرجع. ثم الصلاة على النبي وآله خير الخلائق شافع وشفه. اللهم صل على سيدنا محمد الفاتح لما أخلق وحاد لما سبق ناصر الحق بالحق والهادي إلى صراطك المستقيم وعلى آله حق قدره العظيم. سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله. لا إله إلا الله لا إله إلا الله لا إله إلا الله سيدنا محمد رسول صلى الله عليه وسلم. آمين يا رب العالمين.
All who come before our courts seeking justice, the vulnerable, the voiceless, the poor, and the marginalized, victims longing for redress, and those awaiting judgment. May the administration of justice in our land be marked with fairness, but also with compassion, clarity, and respect for human dignity. As we open this new legal year, we entrust the work and decisions and the challenges that lies ahead into your care. In moments of complexity, great discernment, in times of pressure, grant steadiness. And in all things, may the pursuit of justice serve the common good and strengthen public confidence in the rule of law. We commit our courts, our nations, and this year before you. May your gracious kindness and your mercies be upon us all. This we pray in Jesus' name. Amen.
Thank you very much, the representative of the Christian Council. May Allah subhanahu wa ta'ala grant all the prayers. Amen. Your Excellency, the President of the Republic of the Gambia, Mr. Adam Barrow, the Honorable Speaker of the National Assembly, Honorable Fabaka Tombonjata, my Lord, the Honorable Chief Justice of the Gambia, Honorable Asan B. Jallo, CRG, Honorable Justices of the Superior Courts of the Gambia, the Honorable Attorney General and Minister of Justice, who is ably represented by the Solicitor General and Legal Secretary, members of the Judicial Service Commission, Chairman of the Qadi's Appeal Panel, and members of the Ulamas, Honorable Cabinet Ministers here present, senior government officials here present, the President and members of the Gambia Bar Association and the Gambia Law Society, the Lady Mayors of Banjul, regional governors, President and members of the district tribunals across the country, the Honorable Master and Registrar of the High Court, Deputy Judicial Secretaries, senior administrative staff of the Judiciary and officials of the Attorney General and Minister of Justice, members of the Diplomatic and Consular Corps, landed magistrates and caddies, venerable religious leaders, service chiefs, men and women of various security services, members of the press, support staff of the Judiciary and Minister of Justice, distinguished ladies and gentlemen, all other protocols duly and respectfully observed. Today, Sunday, the 25th of January 2026, marks a momentous and solemn occasion, the official opening of the 2026 legal year, graciously presided over by His Excellency the President of the Republic, Mr. Adam Barrow. This annual ceremony, which stands as a cornerstone of our national legal calendar, is far more than a formal tradition. It is a powerful reaffirmation of our collective commitment to justice, constitutionalism, judicial independence, and the rule of law, values that remain indispensable to peace, democracy, and national development. Historical background of the legal year in the Gambia. Distinguished ladies and gentlemen, the celebration of the legal year dates back to 1982. It was initiated under the stewardship of the Senior Counsel, of the late Senior Counsel and the then Attorney General and Minister of Justice, Honorable Fafa Idris Sambai, of blessed memory. The conception of the tradition came at a critical moment in our national history. In the aftermath of the failed coup and turbulent events of 1981, led by Kukoy Sampasanya, in a period marked by uncertainty and recovery, the celebration of the legal year was envisioned as a symbol of judicial resilience, national stability, and restoration of constitutional order. The first legal year in the Gambia was celebrated on the 21st of November 1982 at Makati Square, under the guidance of the then Chief Justice of the Gambia, Sir Philip Bridges. From 1982 to 1993, the legal year was celebrated annually without interruption. However, following the change of government in 1994, the celebration was observed intermittently. It was not until 2017 that the annual celebration of the legal year was fully restored and consistently observed to this day. Today's ceremony therefore represents the continuation of a proud judicial legacy, one that honors the past, reflects on the present, and sets the tone for the administration of justice in the years ahead. May Allah the Almighty grant us life, good health, wisdom to witness and uphold many more such significant legal years celebration in the years to come. Amen. Distinguished ladies and gentlemen, with this brief historical overview, it is now my distinct honor and pleasure to invite the President of the Gambia Bar Association to deliver her opening statement.
Your Excellency, the President of the Republic of the Gambia, Mr. Adama Barrow, Your Excellency, the Vice President, Mohamed B.S. Jallo, Speaker of the National Assembly, Fabakary Tombong Jatta, Honorable Chief Justice Hassan B. Jallo, Solicitor General Mr. Hussein Tomasi, ably representing the Attorney General, Cabinet Ministers, Justices of the Superior Courts, Venerable Qadis, Your Worship, the Magistrates, members of the General Legal Council and members of the Judicial Service Commission, district chiefs, governors, members of the Diplomatic Corps, the media, invited guests, my learned colleagues, distinguished ladies and gentlemen. In the past year, the legal fraternity lost the following members: Senior Counsel Mr. Fafa Imbai, Mr. Usman M.E. Silla, His Worship Fofana, Senior Counsel Fafa Idris Sambai and O.M.E. Silla were legal giants in the profession. Their contributions will forever be marked in history. On a day like today, we remember them all for their immense contribution to the legal profession, and we pray that the Almighty accepts them into the highest heavens. Your Excellencies, Justice of the Superior Court's invited guests, it is once again my honor to address you at the official opening of the legal year 2026, a moment when we gather to take stock and renew our shared commitment to justice and the values that sustain our democracy. At the dawn of this new legal year, it is fitting that I reflect this time on the enduring partnership between the bar and the bench. The bar and the bench stand as twin pillars of justice, and it is a fact that the independence of the judiciary is safeguarded by the advocacy of the bar, while the integrity of the bar is strengthened by the fairness of the bench. Both institutions are united by common purpose to uphold the rule of law, protect rights, and ensure that justice is not only done, but seen to be done. The private bar brings diverse perspectives, representing citizens from all walks of life. The judiciary, in turn, provides impartial adjudication. Together, they form a dialogue which enriches the development of the jurisprudence. Where the bar advocates, the bench adjudicates, and where the bench interprets, the bar advances. It is effectively this symbiosis that ensures that justice remains accessible, credible, and responsive to society's needs. The past year has seen this partnership between the judiciary and the Gambia Bar Association in the implementation of the British High Commission funded project, which is the building of the brand new court premises at Mile 7 for the Special Criminal Division of the High Court, which I believe will be inaugurated tomorrow, inshallah. We thank the British High Commission through the High Commissioner for their continued partnership to the administration of justice. The revision of the High Court rules by the consultants, AMP and Co., saw collaboration of bench and bar throughout the progress. We are pleased that training will soon begin on the new rules, which are innovative, practical, and designed to ensure smooth administration of justice. As President of the Bar, I wish to recognize the judiciary for its demonstration of the obvious, the fact that the Bar is an indispensable partner in the noble pursuit of justice. It is vital that we continue to nurture this relationship with respect, candor, dedication to ensure that the legal profession remains a beacon of hope and justice for our nation. We're looking forward to the second bench bar dialogue as one of the highlights of this week and the fruitful deliberations that would emanate therefrom, geared towards enhancing justice administration and ensuring justice delivery. We congratulate the government of the Gambia through the Honorable Chief Justice and the judiciary for hosting a successful triennial Commonwealth Magistrates and Judges Association conference in Banjul in September last year. It provided a forum for rich legal exchanges between judges and magistrates from across the entire Commonwealth on a wide range of relevant topics to improve and advance our legal systems, displaying innovation, ethics, and including innovations and ethics to our profession, among other interesting topics. It naturally afforded a great networking opportunity to share best practices among legal professionals from all countries of the Commonwealth. It was attended by members of the bar as well. Thank you for the invitation. While recognizing the big strides made by the judiciary in its quest to enhance justice delivery, challenges still remain. The perennial challenge of financial constraints faced by the judiciary must continue to be a priority of government. The courts provide the last hope for aggrieved parties to have their issues resolved. We urge government to provide the necessary resources to enable them function effectively. On the transitional justice process, government must continue to lead, must continue to support this very important process of ensuring justice and accountability. I know we harp on this all the time, but we must. Accountability for victims of the former regime. For this sends a very clear message that impunity is not an option. Otherwise, it will be hard for victims and the country to move on and out of this transition. I spoke about the Law Reform Commission last year, and I reiterate the fact that it is still not functional. Members have been nominated to it, but it's not operational. The importance of this functioning cannot be overstated, so I will not say more. But there's a lot of work that awaits this commission in the revision of our laws. Just as the law evolves, its tools must move with the times. The COVID period saw the introduction of virtual court hearings, which I consider to have been a blessing in disguise. So more virtual hearings, more automated courts, the recruitment of more judicial officers to man the courts across the country is needed. Incidentally, also security must be provided for all the courts. The recent fire incident at Farafenni Magistrates Court makes it urgent to enhance security in all the courts, all court premises across the country, to avoid such disasters. The Gambia Bar Association is proud of the work being done by the Attorney General and his office prosecuting the case against Myanmar. We are with them. We know that is why the Honorable Attorney General cannot be with us. We wish them all the best, and we know they will continue to do Gambia proud. Your Excellency, Justices of the Superior Courts, our constitutional journey reminds us that democracy is not self-sustaining. It requires vigilance, courage, and integrity. The Bar Association has long stood as a guardian of these principles, defending rights, promoting access to justice, and ensuring that the independence of our institutions is preserved. In doing so, we contribute not only to the legal profession, but to the peace and prosperity of our nation. I wish to reflect briefly on the importance of maintenance of the rule of law. It is vital in any democracy because it ensures fairness and equality before the law, where everyone is subject to the law. It guarantees equal treatment of all, regardless of wealth, status, or political influence. It protects fundamental rights such as freedom of speech, property rights, and access to justice as enshrined in the supreme law of the land, the Constitution of the Republic of the Gambia. The rule of law ensures stability also and accountability in society. Without it, power can become arbitrary, rights can be undermined, and trust in institutions can collapse. So that accountability and limits on power prevents abuse of authority by anyone who can exercise it, by ensuring that nobody is above the law. It provides mechanisms to check government through the independent courts and transparent legal processes. Stability and security, also important. They create a predictable environment where laws are clear, consistent, and accessible. They reduce corruption and arbitrary decision-making, fostering trust in all institutions. Societies without strong rule of law often face chaos, tyranny, or instability. Businesses and investors also rely on legal certainty to operate confidently. They protect contracts, property rights, and fair competition, which are essential for economic stability and growth of any country. The rule of law ensures that governance is based on laws. In times of challenge, it is the rule of law that safeguards these freedoms and preserves the dignity of every citizen. We recall the crucial catalytic leadership and good leadership role played by the Gambia Bar Association during the political impasse in December 2016 presidential elections in defense of the rule of law. Without it, therefore, democracy is bound to falter, peace will be threatened, and trust in the institutions will be eroded. It safeguards the independence of the judiciary. It builds a society where disputes are resolved through reason, not violence, where power is exercised with accountability, where citizens can live in confidence in the fairness of their system. As lawyers and judges, officers of the court, we carry a solemn duty to uphold these principles, to defend the independence of our institutions, and to ensure that justice remains accessible to all, as I said earlier. We recommit ourselves to strengthening the rule of law as a living promise to our people. Your Excellency, my lords, distinguished guests, the membership of the bar is fast growing, with an average of, my own estimates, average of 35 to 40 entrants a year. We warmly welcome them all to the legal profession and the Gambia Bar Association. The Legal Practitioners Act makes pupillage a requirement for all newly called members of the bar, to the bar, and tenancy for newly enrolled legal practitioners. It is a fact, however, that some are finding it difficult to get placement to serve their pupillage. I know the GLC, the General Legal Council, is currently looking into ways to enhance and improve the pupillage system to ensure that all are afforded placement. To this end, the GBA encourages all its senior members qualified to serve as pupil masters to open up their chambers and take pupils under their wings. It is part of giving back by sharing the knowledge, wisdom, and guidance, as was done for us when we needed it at the start of our legal careers. In the past year, some of our members have had to intervene on occasions to mediate and diffuse volatile situations, including the youths of this country desirous of exercising their right to peaceful protest, and law enforcement charged with keeping the peace. We believe dialogue is the way forward. As citizens, we are all on the same side. While protesters are advised to abide by the law at all times, law enforcement, in its role to keep the peace, must also choose to exercise restraint over confrontation. The population relies on them as professionally trained force to handle all situations. Finally, as legal practitioners, we pledge to continue to uphold the highest professional standards, for the strength of the bar lies in the integrity of our members. By enforcing ethical codes, investing in continuing professional development, embracing and encouraging specialization in emerging fields, we can ensure that our practices remain relevant, respected, and trusted, and we will achieve a stronger and more vibrant bar. May this legal year be marked by integrity, courage, and service. Together, let us continue to nurture a democracy rooted in justice and sustained by peace. I thank you all for your kind attention.
Your Excellency, the President of the Republic of the Gambia, Your Excellency, Mr. Adama Barrow, the Honorable Speaker of the National Assembly, my Lord, the Honorable Chief Justice Alhaji Hassan Babukar Jallow, Honorable Justices of the Superior Courts, Cabinet Ministers, Your Worships, Magistrates and Qadi, President and members of the Bar Association, President and members of district tribunals here present, service chiefs, members of staff of the Judiciary and the Ministry of Justice, members of the press, members of the Diplomatic Corps, Excellencies, ladies and gentlemen. It is an honor to address this gathering on behalf of the Honorable Attorney General and Minister of Justice, the Honorable Dauda Jallow, as we commence the legal year 2026. As is widely known, the Honorable Attorney General, the Honorable Dauda Jallow, is currently before the International Court of Justice, where he's leading the Gambia's case against Myanmar, advocating for justice against on behalf of the Rohingya community. Hence his inability to be present with us this morning. Excellencies, ladies and gentlemen, this occasion affords the Ministry of Justice the opportunity to present an account of its work over the past year, to outline ongoing institutional reforms, and reaffirm our commitment to the effective administration of justice in accordance with the Constitution and the laws of the Gambia. As the Attorney General and Minister of Justice, I would like to thank His Excellency, the President of the Republic, for gracing this occasion today. Your Excellency's attendance has now become an established custom, demonstrating Your Excellency's commitment to the preservation of the rule of law, as well as the status and fabric of the judiciary. Since his swearing in as Chief Justice in February of 2017, at a very critical period in the history of this country, the Honorable Chief Justice Hassan Babukar Jallow has served with distinction and excellence. He has over the years strengthened the judiciary, transforming it into a very strong pillar of our democracy. He has indeed been a guiding light for the nation. It is fitting on an occasion like this to give an overview of our work at the ministry. In the area of criminal justice administration, during the period January to December 2025, the Office of the Director of Public Prosecutions continued to discharge its statutory mandate under the Criminal Procedure Code and other enabling legislation. Over 100 legal advices were issued in respect of case files submitted by the Gambia Police Force, the Drug Law Enforcement Agency, and the National Agency Against Trafficking in Persons. These efforts reflect the Ministry's continued commitment to ensuring that prosecutorial decisions are grounded in law, evidence, and due process. The Civil Litigation and International Law Department recorded substantial activity during 2025, and as of January 2026, a total of 206 civil matters were pending before various courts, with land-related disputes constituting the majority. In furtherance of the government's policy objective to strengthen corporate governance and regulatory compliance, the Registrar of Companies has initiated a comprehensive cleansing of the company's registry pursuant to the Companies Act. Public notices have been issued to defaulting entities, requiring them to regularize their findings or face administrative sanctions, including possible striking off from the registry. This exercise is essential to enhancing the integrity of the corporate regulatory framework and ensuring that the register reflects accurate, up-to-date, and legally compliant information. The Alternative Dispute Resolution Secretariat recorded its highest performance to date. It registered 158 cases, over 80% of which were resolved. The Secretariat also conducted a validation of a 5-year strategic and communications plan and expanded public engagement through enhanced visibility and outreach. These achievements demonstrate the growing relevance of ADR mechanisms in reducing court congestion and promoting amicable settlement of disputes. In the area of intellectual property administration, the Ministry continues to advance the protection of intellectual property rights as required under the Industrial Property Act and related instruments. Key developments include strengthening of the industrial property framework and establishment of IP school clubs in senior secondary schools to promote awareness among young innovators. The Ministry remains committed to modernizing IP systems and supporting Gambian creators in regional and global markets. Intellectual property, as is widely recognized, is crucial for innovation, youth employment, growth, and promotion of technological advances. It can create jobs, transform ideas into valuable economic assets, thereby driving economic development. Excellencies, ladies and gentlemen, the introduction of the Civil Registration and Civil Statistics Bill 2025 represents a significant step towards modernizing civil registration processes. The bill seeks to enhance the accuracy and legal certainty of Muslim and Christian marriage certificates, improving record keeping and data integrity, as well as support national planning through reliable civil statistics. This reform strengthens the legal protection of families and promotes uniformity in civil registration practices. Following the adoption of the first national land policy, the ministry has commenced a comprehensive modernization of the deeds registry, including infrastructure upgrades, introduction of digital tools to secure document management and capacity building for registry personnel. A modernized deeds registry will reduce land disputes, enhance transparency, and support the courts in the efficient adjudication of land matters. The National Agency for Legal Aid registered various achievements in 2025. It continued providing legal representation in capital offenses and child-related matters, conducting capacity building through specialized training, including plea bargaining, secured infrastructure rehabilitation, support through the EU UNDP GRADE project, and sustained its operations in Banjul and Basse. While the agency does face challenges like inadequate funding and an ever-increasing demand for its services, it has continued to dispatch its statutory mandate with commendable dedication, notwithstanding these constraints. The ministry is currently negotiating with LexisNexis of South Africa for the publication of the laws of the Gambia in 2026. This publication would update and consolidate the laws of the Gambia. This would give us the opportunity to see all the laws of the Gambia as at 2025 published in a new set of volumes. LexisNexis has demonstrated capacity and can provide historic continuity to undertake such a project of this magnitude for the Gambia, given the fact that it did so in 2009, when we last published the laws of the Gambia. LexisNexis is uniquely positioned in the continent and has an unparalleled record of consolidating and publishing national laws, and has done so for countries such as Botswana, Eswatini, Ghana, Kenya, Mauritius, just to name a few. Your Excellencies, my Lord, the Honorable Chief Justice, you would recall that the Reparations Commission was established by an Act of Parliament in 2023 and became operational in 2025 to implement the TRRC recommendations on reparations. His Excellency's statement at the swearing-in ceremony of the commissioners that there will be annual budgetary allocation to the reparations fund underscores the commitment of the government to put victims at the center of the transitional justice policy, with a view to restoring their dignity and rebuilding their lives. The Commission has begun its work in earnest, and following a series of consultations with stakeholders, and after careful review, it has resolved to adopt a phased payment approach. The first phase of the payments has now commenced and will be made to a total of 83 victims who suffered violations between 1994 and 1996. I would like Madam President of the Bar Association to take note of that. With respect to the Transitional Justice Program and the implementation of the TRRC recommendations, we continue to work with the National Human Rights Commission, which is charged with the responsibility of monitoring our compliance with the recommendations. Substantial achievements have been made in terms of the number of activities that have been identified for completion before December 2027. However, global shifts in external funding have severely affected the progress of the implementation process. In the area of case management, the ministry is currently working with 48, a local IT company, to develop a case management system for its criminal and civil divisions. The objective of this initiative is to design, develop, and deploy a user-friendly and scalable digital case management system that digitizes and automates prosecution and civil case workflows, supporting case tracking, and improve data sharing within and across agencies. It is both fitting and necessary, Excellencies, that we take stock of our collective efforts to uphold justice, promote human dignity, and confront one of the gravest crimes of our time, trafficking in persons. I'm pleased to report that in the past legal year, the National Legal Agency Against Trafficking in Persons has recorded significant and commendable progress in advancing its national mandate. A major milestone achieved during the year was the development of a new 5-year national action plan to combat trafficking in persons. This forward-looking framework is comprehensive and result-oriented, incorporating clear costing as well as robust monitoring and evaluation mechanisms. It provides a strategic roadmap to guide national efforts, enhance accountability, and ensure measurable impact in the fight against trafficking. In the area of investigations and prosecutions, NATIP actively handled 22 human trafficking cases during the past year. Of these, 16 cases are currently before the High Court, reflecting a strengthened investigative process and closer collaboration with prosecutorial authorities. These cases send a very clear message. Trafficking in persons would be pursued with seriousness, diligence, and the full force of the law. 2 significant convictions were recently secured, marking a major milestone in our fight against this grave and exploitative crime. These convictions underscore the state's resolve to enforce the law, protect victims, and uphold perpetrators accountable. With regard to the African Commission on Human and People's Rights, the government continues to meet its obligation with respect to the hosting of the African Commission on Human and People's Rights in the Gambia. A new modern building has been secured by the government for use by the Commission. The building provides more space than the previous headquarters and is equipped with a lift for use by the Commission and its visitors, including persons with disabilities. The Commission will very soon move to its new headquarters, and I want to take this opportunity to make it loud and clear that the Commission is here to stay, and we will do everything possible within our limited resources to ensure a smooth functioning, fit-for-purpose Human Rights Commission for the African continent. Your Excellencies, my Lords, Honorable Speaker, in the light of the forthcoming electoral process, the public is urged not to refrain from hate speech or any conduct that has the tendency to inflame tensions. Such conduct is prohibited under existing law, in particular Section 58 of the Criminal Offences Act, which provides for incitement to violence and hate speech. Individuals are reminded that such conduct is not beyond the reach of the law. Hate speech affects the dignity and human rights of groups and individuals targeted. History has also taught us that hate speech has been used as a tool to mobilize groups against each other, to start wars, conflict, and even genocide. I cannot conclude without joining Madam President of the Bar Association to extend once again our condolences to the families of the late Fafa Imbai and Mr. Usman Sila, as well as Mr. Counsel Fofana. We recognize and acknowledge the immense contributions made by these legal giants to the legal development of this country. We pray that their souls will continue to rest in peace and the Almighty would grant consolation to the families they left behind. Your Excellency, my Lords, distinguished colleagues, ladies and gentlemen, as we commence the legal year, the Ministry of Justice reiterates its commitment to strengthening the rule of law, enhancing access to justice, and ensuring that all justice sector institutions operate in accordance with constitutional and statutory mandates. We look forward to continued collaboration with the judiciary, the bar, law enforcement agencies, and our development partners as we work collectively to advance justice delivery in the Gambia. I wish the judiciary and all justice sector stakeholders a productive and successful legal year 2026. I thank you all for your kind attention.
Your Excellency, President of the Republic, Mr. Adama Barrow, Honorable Speaker of the National Assembly, Honorable Judges of the Superior Courts, Learned Solicitor General, ably representing the Honorable Attorney General and Minister of Justice, Honorable Ministers, Mayor of the City of Banjul, Your Worships, Magistrates and Cadis, Excellencies, members of the Diplomatic Corps, President and members of the Gambia Bar, regional governors, President Seyfolu, and members of the district tribunals, venerable religious leaders, members of staff of the judiciary and of the Attorney General's chambers, distinguished guests, I am honored on behalf of the judiciary and indeed on behalf of the entire legal fraternity to once again warmly welcome Your Excellency, Mr. Adama Barrow, President of the Republic, along with all our esteemed guests, to the premises of the judiciary on this significant occasion marking the commencement of the 2026 legal year. Your continued presence and participation in this ceremony, Your Excellency, reflects your profound commitment to support for the judiciary and for justice, and is highly valued by the bench, by the bar, and indeed all those who are dedicated to enhancing good governance in our nation. In the course of the year, we've lost the company of some of our esteemed members, and as we stand here today, we'd like to acknowledge their work, their contribution to the enterprise of delivering justice, and to pray that the Almighty grants them eternal peace and repose. I would like to express my deep appreciation to the Legal Year Committee, which brings together members, representatives from the judiciary, the Attorney General's chambers, and the Ministry of Justice, as well as the private bar, under the leadership of the indeed indefatigable Honorable Justice Ibrahim Jaite, for the organization of the activities marking the opening of this year. Several events are planned in the course of the year, as you may have seen from the program, to commemorate the commencement of this year. A bench bar dialogue will provide a forum for the two critical stakeholders in the administration of justice to explore ways to alleviate or eliminate the obstacles to the efficient administration of justice, and also to foster greater bench bar collaboration. The training of judges will also feature in the program on the draft civil procedure rules of the High Court. Pursuant to the decision of the Chief Justice to commission a review and propose improvements to the current system of land adjudication, the committee in charge, under the leadership of the Honorable Justice Mahoney, Justice of Appeal, will hold a consultative meeting with regional governors, with the presidents, Seyfolu, and members of the district tribunals on this matter in order to sound out their views. Let me say how much we cherish and we acknowledge the work of the district tribunals, an important, very, very important part of our legal system, and for their contribution to the administration of justice in this country. A separate training programs on the draft High Court rules will also be organized for the legal practitioners as well as the registry and court staff during the Easter vacation, as they all play a key role in the implementation of these rules. In the course of the 2025 legal year, the courts and respective judicial officers and support staff continue to focus on the core mandate of the judiciary. That is to say, the hearing, determination, and disposal of cases. This task was and is always and will be a formidable one, given the complexity of the judicial process the challenges posed by the increases in the case workload, the backlog created by the loss or the departure of members of the judiciary, and other challenges of the working environment. Nonetheless, I'm pleased to report that overall, the courts rose to the challenge reasonably well, and I believe acquitted themselves reasonably well. The 2025 legal year opened with 6,654 cases pending as at the 1st of January 2025 before the trial courts, that is to say, the Cadi courts, the magistrates courts, and the High Court. This does not include the cases before the appellate courts, nor does it include the cases before the district tribunals, which are a very, very significant number. So we started off with 6,654 cases. And in the course of the year 2025, a total of 9,942 additional cases were filed before these courts, compared to 6,678 filed throughout 2024. This represents in 2025 a very significant increase of 49% on the number of cases that we had to attend to in 2025 over what we had in 2024. During 2025, nonetheless, the trial courts disposed of 6,630 cases, which was an increase to the numbers that they dealt with in 2024. In 2024, the courts disposed of 5,541 cases. And this was an increase also in the disposal rate of 19%. This is a commendable achievement, and I wish to acknowledge the work of all those who contributed to this success, the judges, the magistrates, the cadis, together with their support staff, as well as, of course, counsel, both public and private, as well as other participants in the judicial process. Nonetheless, the statistics, however, also unfortunately disclose a continuous steady increase in resort to the courts for the settlement of disputes. And this seems to lead us to the conclusion that litigation, rather than negotiation and settlement, out-of-court settlement, seem regrettably to be the continued preference of the community for the settlement of disputes. We must therefore strengthen the capacity of the courts to hear and determine more cases, but we must at the same time continue to encourage the out-of-court settlement of civil disputes with the assistance of the court-connected ADR system, the ADR Secretariat, as well as our own traditional dispute resolution mechanisms. So despite the laudable efforts of the stakeholders and the disposal of a large number of cases in 2025, this new legal year of 2026 starts off with a heavy caseload of 8,682 cases as at the 1st of January 2026. And we expect more cases to be filed in the course of the year. Hence the importance of building up the capacity of the courts to attend to this case workload, and also encourage out-of-court settlement of civil cases. Speedy trial and quality justice are critical in any democratic society, and these can be achieved by strengthening judicial capacity through adequate staffing, through training, and modern adequate court infrastructure and equipment. Efficient case management systems and clear timelines can help reduce delays. Upholding judicial independence, professionalism, and accountability ensures that justice is not only fast, but that it is fair and that it is reasonable. And we can reduce caseloads by encouraging, as I said, the use of alternative dispute resolution mechanisms which promote peaceful resolution of civil disputes in an acceptable manner, while at the same time fostering reconciliation, community harmony and the resolution of conflicts or disputes in a timely manner. Notwithstanding the heavy workload, as judicial officers, of course, we must and we will continue to ensure that justice is administered diligently, fairly, independently, and impartially, and effectively as well. Capacity building through training, staff development continues, therefore, to be a constant concern and focus in order to equip the institution for the effective discharge of its mission. During the course of 2025, judges, magistrates, and support staff of the courts benefited from overseas training in various jurisdictions with support from the West African Regional Training Center, the Intergovernmental Action Group Against Money Laundering, and the International Law Enforcement Academy, as well as from the People's Republic of China and the Republic of Turkey. We are pleased to also recognize the efforts of the Judicial Training Institute under the leadership of the Honorable Justice Auba for the local delivery of numerous training programs for staff in the past year. The enactment of the Judicial Training Institute bill is, however, still pending at the Ministry of Justice. The time has come for it to be given utmost priority, and we look forward to that, as the bill proposes to establish an institute for the continuing legal training, not just of judicial officers, but of the entire cadre of public legal officers. Capacity building is crucial for efficiency of both judicial and support staff, and it will continue to be a priority in the course of 2026. The judiciary continued to undertake strategic initiatives to guide its operations and development. On 18 December 2025, it organized a workshop for consideration of the extension of the Judiciary Strategic Plan. The extension of the plan, 5-year plan, launched in 2021 by Your Excellency, the President, is both timely and necessary in order to consolidate ongoing reforms and to attend to as yet pending areas within the judiciary. We express our sincere appreciation to the government of the Gambia, to the UNDP, the EU, the United Kingdom, the People's Republic of China, Turkey, and other development partners for their continued technical and financial support for the implementation of key reform initiatives under the plan. But following an extensive review of the plan, it was noted that some of the plan's activities have been undertaken and attained, but much more remains to be implemented. And as a result, the judiciary has decided that the plan, which should have come to an end at December 2025, should have its life extended by a further 2 years to the end of 2027 in tandem with the National Development Plan. Setbacks in the Constitution review and replacement process also impacted negatively on the attainment of the plan objectives, particularly with regard to the restructuring of the judiciary and the full integration of the Islamic Qadi courts as well as the district tribunals into the justice system. Strong expectations were placed on the adoption of a new constitution, which has not materialized due to circumstances beyond the judiciary's control. It is imperative, with the failure of both drafts, it is imperative that these structural judicial reforms, on which there is general consensus, should now be legislated independently of the making of a new constitution. They should instead be enacted by an amendment, either an amendment of the current 1997 Constitution or by the enactment of some other legislation. Policy decisions also by some major donors impacted negatively on the execution of the plan, as we are all aware. And it is necessary always to remind ourselves, and perhaps the government as well, that the government bears primary responsibility for funding or securing funding from partners for the execution of the development plan. A major objective of the plan, that is the development of court infrastructure countrywide in order to facilitate the right of access to justice, has benefited from very limited financial support. Only the Bundung Court Complex, housing a High Court, Magistrates Court, and Kadi Courts, was constructed. The whole of the North Bank continues to remain without any permanent court structure. And the infrastructure in the West Coast region, where with the largest cases, needs to be enhanced with additional new structures. We urge all concerned, including the government, to allocate and release greater resources to fully attain not generally the goals of the plan, but particularly the infrastructure component of it, because this can impact very, very positively on access to justice. And here we continue to appeal for the collaboration and support of not just the executive, but the National Assembly as well, as they are both crucial in this respect. Your Excellency and distinguished guests, when we last assembled here on 9 February 2025, I indicated that the judiciary was looking forward to the equipping of our court records preparation unit with equipment and other facilities with the assistance of the Turkish Cooperation and Coordination Agency, TICA. I am pleased to report that TICA has indeed provided the same, as a result of which the unit is now operational in the Bundung Court Complex. The establishment and operation of this unit is important, as it ensures the expedited preparation of court records, which positively impacts on the progress of cases on appeal. Your Excellency, distinguished guests, the Special Criminal Division of the High Court has been strengthened and now comprises 4 judges. The Criminal Division, as you may be aware, hears cases emanating from the TRRC, as well as other serious crimes referred to it by the Chief Justice. And to date, the superior courts have had and determined 3 cases involving the state versus Yankuba Toure. The courts have also had and determined the case of the state versus Yankuba Baji and 8 others, which largely stemmed from the proceedings of the TRRC. And furthermore, in November last year, Sana Manjang, another individual recommended by the TRRC for prosecution, was arraigned before the High Court Special Division on charges including murder and other serious crimes. The judiciary is well equipped to receive any such new cases and looks forward to receiving them indeed for hearing and determination. The Commercial Division of the High Court was also established in 2025 and reinforced with 4 judges who have received specialized training with the support of the Commonwealth Magistrates and Judges Association, the United Kingdom Judicial College, and the Standing International Forum of Commercial Courts. This commercial division can play a vital role in promoting the speedy and efficient resolution of commercial cases, and that is important not just for justice, but it's important for our investment climate and generally for the Gambia's economy. We wish to record our appreciation for the assistance of the Judicial College and the CMJA for their support. Currently, a court users committee is now in the process of being created in order to secure the support of important local stakeholders for the optimum functioning of the specialized court. Some 2 months ago also, the strength of the subordinate courts was enhanced with the recruitment by the Judicial Service Commission of 4 new magistrates of the first class who, following an induction training by the Judicial Training Institute, have been deployed to various magistrates' courts across the country. Their appointment and deployment has filled some serious capacity gaps in these courts. In addition, the Commission has also appointed 6 legal officers of the judiciary as what we call hurricane magistrates, but they are first-class magistrates who are tasked with the responsibility to write and deliver long-pending judgments and to hear and determine part-heard cases before magistrates who are no longer with the judiciary. I am pleased to report that this initiative has been a great success in clearing this particular backlog of cases in the Magistrates' Court. Between them, the first 4 hurricane magistrates cleared within the 6 months of their appointment last year some 82 cases. Our great appreciation to them, and also to the 2 new appointees who have joined them. The capacity of the High Court bench will also be enhanced through the recruitment of more local judges. The JSC, the Judicial Service Commission, is currently assessing candidates for recruitment. Recommendations also have been submitted by the JSC for the filling of the existing vacancies in the Supreme Court with the appointment of local judges. These 2 initiatives, when they reach conclusion, will see to the strengthening of the superior courts with more judicial officers. And the judiciary in October last year was also enhanced with the promotion of former senior magistrate Ben Fall to the position of Master and Registrar of the High Court. We seized the opportunity to welcome the Master to the senior management of the judiciary. Your Excellency, distinguished guests, the new High Court rules were adopted as planned at a validation workshop in 2025. The rules will come into force this year after promulgation by the Rules Committee. The new rules, which will replace those in force since 1928, provide an improved framework for reducing undue delays and promoting the more expeditious disposal of civil cases in the High Court. We look forward to extending similar reviews and reform this year to the rules governing practice and procedure in the subordinate courts. The court-connected alternative dispute resolution mechanism has been active since 2024. It promotes out-of-court settlement of civil cases. Under the distinguished leadership of the Honorable Omar Njai of the Supreme Court, since the inception of the mechanism, a total number of 232 cases have been referred for mediation. Out of these, 33 have been successfully mediated, settled, and returned to court for the entry of consent judgments. A total of 112 cases has been returned to the judges concerned for continuation of proceedings following unsuccessful mediation, and a total of 88 cases presently pending and subject to ongoing mediation. The ADR registry is better staffed now. However, challenges persist in the operation of the mechanism. Some legal practitioners, some lawyers appear reluctant to engage with the mechanism, preferring litigation. Judges too, I must say, need to make greater use of the mediation mechanism. And I continue to appeal to both of them to lend their undiluted support to this worthy initiative. The previous year also saw the creation of new mechanisms and the strengthening of the existing ones in order to monitor and enhance the performance of judicial officers. In March 2025, pursuant to Direction Number 1 of 2025 issued by the Chief Justice under Section 1431 of the Constitution, the High Court Monitoring and Supervisory Committee was established and mandated to monitor, supervise High Court proceedings, and evaluate judges' performance, including the quality and timeliness of decisions and court management practices. The committee chaired by the Honorable Justice Njai is now fully operational. Its work is essential in promoting efficiency, accountability, transparency, and the timely delivery of justice by the High Court. With the establishment of this committee, joining the already existing Subordinate Courts Monitoring Committee, presided over by the Honorable Justice Silla, the Kadi Courts Monitoring Committee under Honorable Kadi Seka, and the Judiciary Prisons Visiting Committee under the Honorable Justice Sahu Sise, all the tried courts in the judiciary are now subject to some mechanism of close monitoring and supervision in their case management. The institutional regulatory framework for the judiciary has also been the focus of much attention in the course of the past year. The Judiciary Regulatory Committee, chaired by the Honorable Justice Wright, is to be commended for finalizing and submitting the schemes of service for all cadres of staff within the judiciary, the Employee Handbook, the Human Resources Handbook, the KPI templates, and human resources forms. And we plan to have all these documents come into effect this year. As part of ongoing reforms, the judiciary is also in the process of establishing a comprehensive evaluation and appraisal system for all judicial officers as part of efforts to strengthen accountability, professionalism, and performance. A committee has been constituted to spearhead this initiative, chaired by the Honorable Justice Jallo of the Supreme Court. Its work has reached an advanced stage, and we look forward to draft proposals in the first quarter of this year. The introduction of such a framework, an appraisal framework, is important in promoting efficiency, transparency, and continuous self-improvement. It will also provide objective criteria to fairly assess judicial officers' performance, thereby informing transparent and merit-based promotion decisions. And the system is expected to be fully operational before the end of 2026. And eventually, annual performance evaluation systems will be established for all staff within the judiciary. As part of ongoing efforts to strengthen governance and institutional accountability, a committee under the leadership of Honorable Justice Jallo of the Supreme Court is currently drafting JSC regulations to fully regulate staff matters within the institution. The judiciary currently operates under the General Public Service Commission regulations, which govern the civil service as a whole, but which do not cater for the specific needs of the judiciary. So the enactment of our own regulations is critical, as it will provide clear and transparent procedures for the appointment, discipline, and administration of all staff, taking into account the specific, unique features of the judiciary. I am pleased, indeed I would say we are all pleased, that in the course of 2025, all staff of the judiciary benefited from salary and allowance upward adjustments in line with those in the rest of the public service. The enactment of the Judicial Officers Condition Service Act has also cured the discrepancies and disparities between the emoluments of judicial officers on the one hand and those of members of the Executive and National Assembly on the other hand, and restored the parities which hitherto existed in this regard. The Act, in making special provision for the pensions of judges, has given due recognition to the unique position of judges and the established practice in this regard in Commonwealth jurisdictions. And we expect that these measures will facilitate the recruitment and retention of suitable Gambians to the bench. On behalf of the judiciary, I wish to commend His Excellency the President and the members of the Executive, as well as the members of the National Assembly, for their approval of these measures. Your Excellency, distinguished guests, with support from the British government, the first phase of the reconstruction of the High Court in Barrow Mile 7 is complete, and the premises are ready for use. The inauguration of the new building is part of the activities marking the opening of this legal year. It will create additional courtroom space, ease congestion, and enhance access to justice. It will provide a more conducive environment for judges. Additionally, as part of the second phase, support from the EU GRADE project through the UNDP and the Bar Association, another facility at Barrow Mile 7 is also under reconstruction and expansion to provide for two more courtrooms. Both structures have been earmarked for use by the Special Criminal Division of the High Court, which is mandated to hear and adjudicate inter alia TRC-related cases. Your Excellency, distinguished guests, the judiciary continues to face numerous challenges which stand in the way of attainment of its mission. Shortage of courtrooms and office space continue to hamper optimum utilization of judicial officers. There is need for adequate space to accommodate and to ensure the full functioning of all courts. Additional, well-equipped and furnished courtrooms are fundamental. They are absolutely essential. They are necessary as they positively impact on the delivery of justice. Inadequate funding for daily operations inadequate support services, lack of adequate transportation for staff, and mobility constraints for judicial officers all continue to beset us. And these all put together affect our efficiency. The suspension of funding by some donors has, of course, adversely impacted the expansion, for instance, of the computer-aided recording and transcription system and the electronic case management system within the judiciary. That suspension has disrupted the implementation of key reform initiatives and infrastructure development efforts. As a result, several planned activities were delayed or curtailed in the course of 2025. We are very pleased that the UNDP and the European Union are agreeable to picking up some of these projects, and we look forward to working with them. The legal year 2026, looking ahead, should be a period for us to focus ever more on our core judicial mandate. This will require greater diligence by all judges, magistrates, cadis, and their support staff, as well as by legal practitioners, other stakeholders, and all persons who are in contact with the judicial process. The extension of the Judiciary Strategic Plan for another 2 years should be an opportunity to implement the remaining activities which have been identified for priority action. Amongst them, as I said, the additional courtrooms, the consolidation and extension of the specialized courts, the promulgation of the new High Court rules and training of the stakeholders on their implementation, the review and replacement of the subordinate court rules, the improvement of the regulatory framework with adoption of JSC regulations, the adoption of the schemes of service and code of conduct, and a staff judicial officers' performance evaluation and assessment system, the adoption of a new and more efficient mechanism for the adjudication of land disputes, the enhancement of our capacity for staff development with the enactment of the new GTI legislation, training for staff, recruitment of additional local judicial officers at all levels. These are all priorities which we need to give urgent attention in the course of this current new legal year. We look forward as well to rolling out the court's computer-aided transcription system, which is proving to be very fantastic, to all the other remaining courts. We look forward to the implementation of the electronic case management system and to progress in the digitization of court processes and court records. The tragic incident at the end of last year, the burning down of the Farafenni Magistrates Court, which resulted in the loss of all court records and equipment, is a very painful reminder of the danger of reliance on paper records. And this is not just for the judiciary, but for the entire public service, reliance on paper records, and the need for digital backup of the court archives and records. It is equally a reminder of the responsibility of state security agencies to protect state structures and resources, including all court premises countrywide. The cause of the fire is currently unknown and is under investigation by the police. Meanwhile, measures are being implemented by the judiciary for the reconstruction of both the structure and the records of the court, which has now resumed operations from temporary premises. Our focus on the independence, on the autonomy, and the efficiency of the judiciary and the machinery of justice will continue to be unwavering. The successful implementation of all these foregoing measures requires the fullest support and collaboration of many stakeholders, with funding and with other assistance from and by the government, from the executive, the National Assembly, the bench and the bar, local stakeholders, and the Gambia's friends amongst the donor community. And we look forward, we are optimistic of such support in the course of this legal year, so that together we can strengthen the rule of law and democracy in the Gambia, strengthen it through an independent, efficient justice delivery system, and with the assurance and with the knowledge that investment in justice is an investment for the rule of law, is an investment for democracy, is an investment for peace and for progress. I now have the great honor to invite His Excellency, the President of the Republic, Adama Barrow, to address the gathering and to declare the 2026 legal year open. Your Excellency.
My Lord the Chief Justice, Justices of the Superior Courts, Honorable Speaker, and National Assembly members, Honorable Attorney General and Minister of Justice, Honorable Cabinet Ministers, Your Worships, the magistrates and cadis, District Sefolu, and members of district tribunals, President and members of the Gambia Bar Association, members of the Diplomatic and Consular Corps, staff of the Ministry of Justice and the Judiciary, distinguished ladies and gentlemen. It is my honor to preside over the opening of the 2026 legal year. This event annually allows us to reflect on the status of our justice sector and to reaffirm our commitment to the rule of law and effective justice delivery. The administration of justice remains a cornerstone of our democracy, principally because a strong, independent, and efficient judiciary is indispensable for peace, stability, good governance, and sustainable development. This makes our judicial reforms and modernization process mandatory. It is reassuring, therefore, that the implementation of the judiciary sector strategic plan has already yielded notable achievements. These include improvement on case management, enhanced access to justice, strengthened judicial independence, and sustained capacity building for judicial officers and staff. Digitalization efforts mark another transformative endeavor towards greater efficiency and transparency in our legal system. This aligns with the emphasis of the Commonwealth heads of government on innovation in judicial practice and embracing change for a better future across member states. My Lord the Chief Justice, distinguished personalities, I particularly commend the establishment of the Interdepartmental Committee on Land Dispute Adjudication. It reflects strong leadership and a deep understanding of the challenges facing our justice system. We eagerly await the committee's recommendations to solve the growing volume and complexity of land-related cases in the country. The outcome of this process is expected to strengthen impartial and timely dispute management. Relatedly, last year, my government enacted the 2025 Judicial Officers' Conditions of Service Act. This landmark legislation is to guarantee judicial independence and enhance the welfare and professionalism of judicial officers. The Act affirms the judiciary as a key arm of government. By improving its remuneration packages and working conditions, the sector will attract and retain qualified officers, reduce the risk of corruption, boost efficiency and impartiality, and reinforce public trust in the justice system. To complement these reforms, the Ministry of Justice is developing a digital case management system for our courts. This initiative reflects our determination to modernize legal practice and ensure that the government legally meets the highest standards of dispensing justice. I am pleased to announce that I personally approved the request to replace the old fleet of vehicles for judges in the superior courts. The new vehicles will be delivered soon to allow our judicial officers discharge their duties with dignity and efficiency. Distinguished ladies and gentlemen, following the ECOWAS authority of head of state and governments, approval to establish a special tribunal here, we have enacted the Special Accountability Mechanism Act and the Special Prosecutor's Office Act to prosecute perpetrators of gross human rights violations from July 1994 to January 2017. Consequently, I have directed the Attorney General and Minister of Justice to appoint a special prosecutor to commence work soonest. The establishment of a special division of the High Court is an added highlight to our quest for accountability and reconciliation. It reflects our collective resolve to confront past acts of injustice while building a future grounded in truth and the rule of law. In addition, the Minister of Justice is currently leading a legal team at the International Court of Justice, ICJ, to argue our case against Myanmar. The merits hearings began on 12 January 2026, marking the first time in over a decade that the court has held full merits hearings in a genocide case. We are optimistic of a favorable outcome that would uphold justice for the Rohingya people and reaffirm the binding nature of the Genocide Convention. This historic case underscores that my government respects international law, human rights, and accountability. Incidentally, the case has firmly placed the Gambia on the global stage as a principal defender of justice internationally. In 2025, we also support a resolution at the United Nations General Assembly requesting an advisory opinion from the ICJ on the obligations of states in respect of climate change. Together with other countries, we maintain that the climate obligations of states arise from multiple sources of international law. The court ruled that states have binding obligations on the climate treaties, customary international law, and other treaties to protect the climate system from greenhouse gases emissions. They maintain that international breaches constitute wrong acts, thus requiring redress. On human rights and good governance, the Gambia's engagement with the Universal Periodic Review, UPR, process remains central to our human rights accountability and democratic governance commitment. Last January, we went through our fourth UPR review before the Human Rights Council in Geneva. Out of 309 recommendations, we accepted 273, significantly improving on our previous performance. Led by the Minister of Justice, the Gambian delegation presented updates on ongoing reforms on transitional justice, corruption, access to justice, and institutional strengthening. We acknowledge our reporting obligation to the UPR, but recognize the process as a mechanism to improve the lives of our people. We remain committed, therefore, to acting on accepted recommendations and working closely with the National Human Rights Commission, civil society organizations, and our international partners. Esteemed personalities, ladies and gentlemen, like other concerned citizens, my government is strongly opposed to corruption. I am thus happy to announce that the appointment of the commissioners earmark for the Anti-Corruption Commission will be finalized soon. The would-be commissioners have extensive experience and sense of professionalism and dedication to public service, high enough to lead the fight against corruption. To comment briefly on the policy and vision of providing a strategic direction for the legal sector, the Ministry of Justice, with support from the European Union, is developing a comprehensive justice sector policy. This policy seeks to outline my government's vision for a modern, accessible, and effective justice system. It will serve as a roadmap for continued reform and institutional strengthening across the justice sector institutions. Proudly, all these have been achieved under the distinguished leadership of the Honorable Chief Justice Hassan B. Jallow. His service to the nation is one of distinction, marked by a visionary stewardship of our judicial institutions and a strict devotion to judicial independence and the rule of law. Under his inspiring guidance, the judiciary has implemented groundbreaking reforms that have strengthened access to justice, enhanced institutional capacity, and advanced the professional standing of our judicial officers. The Honorable Chief Justice has already earned himself a reputable legacy of integrity, wisdom, and progressive leadership that will impact our justice sector for ages. As we open the 2026 legal year, let us renew our shared commitment to justice and honest service to the people, strengthen the rule of law, protect the rights of all, and build a justice system that inspires confidence, promotes equity, and upholds the highest ideals of our republic. To conclude, be assured that my government will remain supportive of the legal sector institutions for the fulfillment of their constitutional mandate. I wish you all a productive and successful legal year.